This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Hello everyone, I'm Leonard French, your favorite copyright attorney, and I have quite the Liebowitz story for you today. Yesterday, I think it was Dan Booth who tweeted out this weird thing that appeared on the docket. You might remember that we talked about this case. This is not a case you have not heard about before. We covered this in a previous video that I can, I guess, link to in the chat here, and in the description when the live stream is ended. But we did cover this before. And so what we have today here is a strange docket entry. You don't normally see a docket entry like this. This is docket number 23, and it's from July 14th, just yesterday, and it says order. So this is the court writing an order. The Judge Stacy M. Yandell. While hybrid representation, i.e. a represented party filing papers on his or her own, is generally prohibited, and then cites to two cases about that, plaintiff's assertions in the attached letter are directly material to plaintiff's exposure to and liability for attorney's fees and costs being sought in a motion currently pending before the court. See docket number 10. So $24,000 is what we're talking about, the attorney's fees in this case. This is the case where Liebowitz filed in southern Illinois when it was meant to be in northern Illinois, and it was suspected that he was trying to do an end run around the northern Illinois court by just filing in southern Illinois, kind of getting the plaintiff's attention and then getting a settlement. But that didn't happen. I think it was Dan Booth from Booth Suite, or maybe it was just him Booth as himself. I'm not sure if it was a law firm or not. Represented the defendant and got the case moved to the Northern District of Illinois, where then the case was further dismissed. And now we're talking about the $24,000 in legal fees, or I think it was 40 some, but got bumped to down to 24. So we get a weird order. Accordingly, the letter shall be included in the record for the court's consideration. So good, we get the letter. We're going to take a look at the letter in just one second. In light of the attorney-client privilege, though, absent a subsequent motion demonstrating good cause for unveiling other documents submitted with the letter, those documents will not be filed on the docket. So we know that whatever we're about to look at, the person sent a letter and a bunch of documents. Well, I'm not going to bury the lead here. The person who sent the letter is none other than the client of Liebowitz, Glenn Craig. And Glenn Craig writes directly to the judge, who then puts Glenn Craig's papers on the docket, or in this case, the 2 pages of the letter, and not whatever was attached. Since she said that it involves attorney-client privilege, I'm assuming that Glenn Craig forwarded communications between himself and Liebowitz that support this letter. So let's see what he has to say. It's quite remarkable. Dear Judge Yandell, I learned for the first time last week. This is July 8th, 2020. I learned for the first time last week about a case that Richard Liebowitz filed in this court in 2018 in my name, Craig v. Pop Matters, Inc. Boom! What? The client doesn't know that Richard Liebowitz filed a case. Okay, like there's a lot there. Let's finish the letter and then we'll kind of go over what this means. He dismissed the case and Pop Matters has a motion pending for its attorney's fees. This is all a total surprise to me. Richard blindsided me. He didn't tell me anything about this case or another case he filed in the Northern District of Illinois until yesterday, after I demanded an explanation. He never told me Pop Matters used my photograph. He never asked me if it had been licensed to anyone, or I would have told him about my license to Sony. He never told me he was going to file either lawsuit, and he did it without my knowledge and without my permission. No, don't ever do that as an attorney. You never ever take action without your client's knowledge or permission. He never told me Pop Matters made offers to settle in each case. That's a violation, if true. That's a violation of the rules of professional conduct, which say that you must take settlement offers back to your client. So now here's what I'm thinking. If this has happened to one client, and Liebowitz has filed a record number of cases, so many cases that us other attorneys question whether he's competent to file that many cases at one time, and if you did file that many cases, that there would be shortcuts taken. We wonder what other shortcuts and what other clients and what other lawsuits has this been done. He never told me Pop Matters filed a motion for attorney's fees in either case. He never consulted me about anything. I retained Richard Liebowitz in 2016, and he filed and settled several copyright lawsuits for me for a contingency fee. That also tells us Richard Liebowitz is operating on contingency fee agreements. That's just a thing. It's a fact, so that we can sort of understand his motivations and things. But I now understand he has been operating in stealth mode. He does not abide by the rules of conduct set by the Bar of New York or the terms of the retainer agreement we signed in 2016, which is attached. Okay, so that's one thing. That's one reason. That's one thing the court would not show you, is because that's between him and his attorney, is that retainer agreement. I'm not entirely sure how confidential the actual retainer agreements are, but I'm going to err on the side of caution and say that they're probably considered attorney-client privilege. In the retainer agreement, he agreed to, quote, keep you informed of the status of your matter and agree to explain the laws pertinent to your situation, the available courses of action, and the attendant risks. Richard violated that at every step of this case. I agreed to fully cooperate with the firm in the administration of the matter and to seriously consider any settlement offer that attorneys recommend before making a decision to accept or reject such offer. Richard made that impossible because he never told me about the lawsuit or Pop Matters settlement offer. I have now seen the response that Richard filed in this court on June 11th, 2020, without consulting me. He wrote, plaintiff chose the Southern District of Illinois as his venue of choice in part due to the availability of his counsel, Liebowitz Law Firm. But I was never consulted about this action and did not choose to file it at all. I would not have authorized filing it in this court if Richard had asked. Richard made every choice, not me. He also wrote that defendant has failed to show that plaintiff's counsel acted in bad faith, and therefore the request for sanctions should be denied. I do not know how Richard filing a lawsuit without my knowledge could be anything other than bad faith. Richard did all this behind my back and without my authority. I had no idea about this lawsuit or the lawsuit in the Northern District of Illinois until I got a demand from Pop Matters' lawyer on June 29th, 2020 for the attorney's fees award that was entered in the Northern District of Illinois in March, also without my knowledge. I sent Richard an email on July 6, 2020. Richard, is this once again something you did and did not relay to me or ask me over 2 years ago? Okay, wait a second. Once again? Richard, is this once again something you did and did not relay to me or ask me over 2 years ago? So there's something else he did with this client already? Quote, I have not spoken or heard from you since February of 2020, and now this? Please explain what this is and how I got mixed up in this matter. We talked yesterday, July 7th, 2020. I told him what I knew about the case and asked him how come you didn't come to me. He had no response. He tried to put the onus on me. It's par for the course, he said. You roll the dice. You see what you get. I'm not the one who rolled the dice. That was all Richard. Last year, in another case, I caught him negotiating a settlement under the table without my knowledge. There you go. That's the other thing. That gets attorneys in trouble too. I think, didn't Mark Randazza get in trouble for something similar? I'm not saying the rest of the facts are similar, but just the initial fact of doing something without the client's permission. There are other cases that he filed in my name and that I only found out about after the fact. This whole case is malpractice. Wait, skip that. There are other cases he filed in the guy's name? What? This whole...
doesn't think they're relevant because he's talking about this case to this judge.
Yeah.
You know?
This whole case is malpractice, a breach of my agreement with Richard, and a total fraud. Now I know he's a scam artist, and I don't want to be another one of his victims. I understand that Pop Matters asked for its attorney's fees either against me under the Copyright Act or as sanctions against Richard. He should have to pay the award, not me. I am asking you to please consider the facts of this matter and require Richard Liebowitz to pay the attorney's fees to Pop Matters. Sincerely, Glenn Craig, unsigned. I'm not exactly sure what effect the unsignedness has to it. I'm assuming the judge isn't going to stop at this letter and consider this fully found testimony. I think the judge is going to haul Glenn Craig into court, either remotely or actually physically into court, and ask some questions under oath and see what should be done about Richard Liebowitz. Real quick, before we get into the rest of the motion for the attorney's fees, let's take a look at the definition of fraud. Fraud is the wrongful or criminal deception intended to result in financial or personal gain. So just follow this out with me. It's the basic dictionary definition of fraud. We're not talking about a legal criminal definition of fraud at the state level. We're talking about sort of a higher level, general definition of fraud. This is wrongful deception intended to result in personal gain. It's Richard Liebowitz taking an opportunity that he himself doesn't have. I'm a copyright attorney. I can't just go start filing copyright lawsuits. I need to have a basis for them, right? I need to have a copyright claim. Well, am I very good at going and generating copyright claims? No. But other people who have found them inadvertently, photographers, for example, have plenty of copyright claims. So Richard Liebowitz goes, this is a hypothetical here, but it's by speculation. Richard Liebowitz goes and gets hired by a photographer and sees a treasure trove, a veritable dragon's hoard of copyright lawsuits just waiting to be filed. And all he has to do is just keep filing them. In fact, we know that he files them in droves. He files them by the horde. He has filed, 1,500 lawsuits or something, or more than that, 2,000 lawsuits or something. He's probably the single highest individual filer of copyright lawsuits ever. Strike 3 Holdings or Malibu Media, they're higher, but Liebowitz is the only solo or small firm attorney that's really doing that, and especially at that level. So we know he's filing them in droves. Well, where's he getting them all from? Does he take shortcuts? Is this maybe a shortcut that he's taken as he sees that this guy's got 100 copyright claims, and so he just starts going through them regardless of whether the client authorized it or not? The client will be happy when I win him some money, not realizing or not even caring about the risk that Liebowitz is exposing the client to in the process. And so it all goes fine until one of these cases blows up, and then Liebowitz is now on the hook, not just for the $24,000, but also for the lying about the whole thing, misrepresenting that he had client authorization to file this stuff, acting in his own best interest when he has a fiduciary duty to act in his client's best interests. So he's probably getting criminally charged for this. I don't see any way that he's not. It might take some time for the various prosecuting bodies to catch up with him, but this is either some kind of fraud in Illinois or some kind of fraud in New York. I think the client is from New York, so it would probably work in New York, and the court matter is in Illinois, so it probably works in Illinois too. He could probably get charged in both jurisdictions, one for the fraud to the client and one for the fraud to the court. And I can't see any way he's not disbarred for this alone, let alone an entire history of misconduct and then this. So, yeah, I think that's the end of Liebowitz. And I think a little bird told me he has not filed any new lawsuits since June. So we're already into July. He normally files a whole bunch of lawsuits. And now it's in the middle of July and he hasn't filed anything new. That, just again, not just speculation. Someone else told me, so I'm not 100% certain on it. So what got us here was this statement of relevant facts, in case you just want to know what the problem is here. Glenn Craig now, we know, is a photographer based in New York City on assignment for the short-lived magazine Zygote in June 1970. He took a series of photographs of Miles Davis, including the photograph at issue in this action, during Davis's 4-night residency at the Fillmore East. His Davis series then lay dormant until the 2014 release of Miles Davis, Miles at the Fillmore, the Bootleg Series Volume 3, a 4-CD box set of recordings of those Fillmore East concerts. By agreement, February 18th, 2014, Craig licensed Sony Music Entertainment's Legacy Recordings division to use the photograph and 12 of his other Davis photographs inside the music packaging of Fillmore, and further licensed the photograph and one of the others for publicity. Legacy released Fillmore March 25th, 2014. One Craig photograph appears on the CD Digipack's back cover. 12 more by Craig are in the Fillmore booklet, including the photograph. To promote Fillmore, Legacy sent advanced copies and press materials to media outlets, providing a copy of the photograph with editorial uses by internet review outlets expressly permitted. Pop Matters is a corporation in Chicago. It runs popmatters.com. It received Legacy's promotional materials and ran a Fillmore review on its website. It ran a review of the Miles Ahead soundtrack with the photograph on April 20th, 2016. Then Craig, through Liebowitz, initiated suit against Pop Matters in this court on September 11th, 2018, alleging infringement. On September 27th, Pop Matters was served, and Pop Matters was given Pop Matters in reverse served a Rule 68 offer of judgment for $800. So they offered $800 to settle the matter. Liebowitz made a counter offer of $25,000. And of course, now we know that that wasn't something that apparently was run by the client in violation of your rules of professional conduct. Let me see if I can find that. There is an RPC about settlements. A lawyer's duty under RPC 1.4. Let's take a look. So we have the American Bar, Rules of Professional Conduct for Lawyers. A lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required. A lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. A lawyer shall keep the client reasonably informed about the status of the matter. A lawyer shall promptly comply with reasonable requests for information, and a lawyer shall consult with the client about relevant information. And then B, a lawyer shall explain the matter to the extent reasonably necessary. I guess somewhere in here is their comments about settlement. Yeah, for example, a lawyer who receives an offer of settlement must promptly inform the client of its substance unless the client has previously indicated that the proposal would be acceptable or unacceptable. So unless Glenn Craig had authorized this denial of the $800 settlement offer, then Liebowitz is in violation of his rules of professional conduct as well, and I would urge Glenn Craig to file a complaint with the disciplinary committee, with the disciplinary bar of New York State against Liebowitz for doing this to his client, for misrepresenting, for filing an action on behalf of a client without the client's knowledge. I mean, it's just absolutely untenable. The way that lawyers back up these motions for attorney's fees then are to show how many hours they worked. And in order to show how many hours they worked, they not only have a log of the hours that they worked, and you can see here, giving a little bit of a professional analysis to this Booth Suite email, or just this Booth, I'm looking at the word email, this Booth Suite invoice, or statement of professional services rendered. Look at what's not on here. You don't see a lot of point 1s, point 1, point 1, point 1. They only seem to bill for the substantive work, not for, I touched your files, so we had to, bill you for that. And so itemized attorney services, $25,585, just in the attorney services, not in court costs. And then what you do is you back that up with an affidavit. This is a declaration, which is the same thing as an affidavit under oath, but this is a declaration under penalty of perjury. So he will declare under penalty of perjury down here, probably at the end. I declare under penalty of perjury that the foregoing is true and correct. And so he makes a 15-page argument for why he should get his attorneys, by Pop Matters defendant and Booth Sweet, should get their attorney's fees paid for because the action filed by Glenn Craig is frivolous. That this was a authorized use of the photograph, and if it was somehow an unauthorized use, fine, they were willing to pay an $800 settlement, and that should have resolved the matter. So since that didn't resolve the matter, and the defendant had a reasonable reason to rely on the fair use or authorized use of the photograph, that Leibowitz's pursuing of the lawsuit is frivolous and vexatious, basically. And now we've sort of confirmed that it's really frivolous and vexatious if you file it and you don't even have permission from your client, and your client wouldn't have given permission. And it's the second time that Liebowitz has filed a lawsuit on behalf of this client without permission. So what else has Liebowitz done for other clients without their permission? Probably in furtherance of Liebowitz, not in furtherance of the client's best interests. And that, I think, is what makes it fraud and a violation of the rules of professional conduct. So what do you think of that? That is some serious stuff that Liebowitz... we just don't want people like that being lawyers. Liebowitz should be disbarred. I've called for it before, but this really is... there should be some emergency action taken, and maybe the disciplinary committee could step it up a bit, because there's no way he should be representing people when he's not even telling them that he's filing lawsuits, and then incurring the risk and exposure of attorney's fees, $24,000 in attorney's fees, and the client, the plaintiff, didn't even know that they were filing lawsuits in their name. You should be able to super chat as a wedding gift. You can super chat as a wedding gift. I don't know why you wouldn't be able to super chat. But yeah, talk about surprise Liebowitz. Yeah, we got a surprise Liebowitz this time. It was very much a surprise. And I think he's going to be charged with some kind of fraud or something. He has to be. There's just too much. He's too much of a target. He's done too much wrong, not just mistakes, but worse. Clockwork, thank you for the $10. Love the channel. Your videos have shown the interesting ride that Leibowitz's career had been. Do you think it was because he was in a sort of Ponzi scheme situation? Yeah, that's something that happens. That's a fairly common way that law firms fail. So it takes a certain amount of money to live, right? And it takes a certain amount of money to run the business. And so if you aren't super careful running your business, you might end up owing more money than you're making. And so you have to start trying to charge more money. Well, clients don't often just want to pay more money. So what you start doing, and this is how it goes wrong, is you start advertising for more and more and more clients, and you keep taking the clients on, even though you might not have the capacity or the competency to be able to handle that many clients, but you take them on because you need the money. And so the new client's money starts to be used to cover for the debts and expenses that are already existing, not to cover the new client's matters. And so then you need more new clients to cover the first round of new clients, because the first round of clients covered the old clients, and the second round of new clients is being covered the first client. And now you need a third round of new clients to cover the second. And if you mess any of this up along the way, now you need a fifth round of clients to cover for the third round of clients, and a sixth round of clients to cover for the fourth round of clients, and a seventh round of clients. And you see how it just snowballs down the hill and just keeps on rolling and building. And I have no idea. I'm hearing noises from my front walk, so I hope it's not somebody trying to get in my house. Love your show. Congrats on getting married. Thank you to... I'm sorry, I have 3 monitors now, and Michael Dale, thank you to Michael Dale. And Kyle Seifring, $2. What if Liebowitz can't pay? Well, Liebowitz will bring that up with the court and explain why he can't pay, and the court will deal with him then. If he doesn't bring it up, then he's just in contempt of court, and the court will deal with him much more harshly then. Dalek Sex, £5, wedding present. Thank you. Really appreciate that. So yeah, that is Richard Liebowitz very likely starting to get, on the final path to being disbarred or suspended or something. We really need to have some action on this, New York. So
I just wanted to add to the whole Ponzi scheme thing. Another part of it that makes it very difficult to run your law firm is when you're getting sanctioned every other case for $3,000, $5,000, $40,000.
Yeah.
You start the, the normal costs of running a law firm. Normal costs of running a law firm are really high. I mean, just ask Leonard.
Yeah.
And he's not getting sanctioned every time he touches a case. You know what I mean? So,
yeah.
Richard's got to be hurting pretty bad at this point.
And that's our show, everyone. Thank you very much to all of our supporters who support us on patreon.com/ljfrench and sponsus.com/law. Special thanks to BU1 Simmons in the month of July. Really appreciate your support. Thank you to the July $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to Janos Pastor for the £5, a tiny contribution to your honeymoon or expenses putting up with bureaucracy. Wow, NG, $50. Thank you very much. Congratulations. Thank you for your hard work explaining this law to us lay people. And Anna Daisy Bird, thank you for the $2. Congratulations. And thank you to the July $5 plus supporters who are scrolling on the LED panel. Everyone's in the description of the videos. I'm Leonard French, your favorite copyright attorney. Thank you for joining me. I'll let the music play out while I answer some of your questions via chat, and we'll see you in the videos that drop. Have a good one. Don't forget your taxes, US. That's due today. Bye. Thank you to MK Painter for the $10 and the thank you animation. All right, we're out in 10. I'll see you guys. Have a good one. Bye.